For this video, we are going to tackle Article 153 of the Revised Penal Code, which is the crime of tumults and other disturbances of public order. Article 153, tumults and other disturbances of public order. The penalty of arresto mayor in its medium period to prisión correccional in its minimum period and a fine not exceeding 200,000 pesos shall be imposed upon any person who shall cause any serious disturbance in a public place, office, or establishment, or shall interrupt or disturb public performances, functions or gatherings, or peaceful meetings, if the act is not included in the provisions of Articles 131 and 132. The penalty next higher in degree shall be imposed upon persons causing any disturbance or interruption of a tumultuous character. The disturbance or interruption shall be deemed tumultuous if caused by more than 3 persons who are armed or provided with means of violence. The penalty of arresto mayor shall be imposed upon any person who in any meeting, association, or public place shall make any outcry tending to incite rebellion or sedition, or in such place shall display placards or emblems which provoke a disturbance of the public order. And finally, the penalty of arresto menor and a fine not to exceed 40,000 pesos shall be imposed upon these persons who, in violation of the provisions contained in the last clause of Article 85, shall bury with pomp the body of a person who has been legally executed. What are the punishable acts under this article? First punishable act, causing any serious disturbance in a public place, office, or establishment, if the act is not included in Articles 131 and 132 of the Revised Penal Code. Second punishable act, interrupting or disturbing performances, functions, or gatherings, or peaceful meetings. Again, if the act is not included in Articles 131 and 132. Take note here that if the serious disturbance in the first punishable act or the interruption in the second punishable act is tumultuous in character, the penalty will be next higher in degree. Third punishable act, making any outcry tending to incite rebellion or sedition in any meeting, association, or public place. Fourth punishable act, displaying placards or emblems which provoke a disturbance of public order in such place. And number 5, burying with pomp the body of a person who has been legally executed. So, take note of these 5 punishable acts and we will discuss each of them in the succeeding slides. Let's go back to the first punishable act, causing any serious disturbance in a public place, office, or establishment, if the act is not included in Articles 131 and 132 of the Revised Penal Code. So, Article 153 makes mention of Articles 131 and 132. But Articles 131 and 132 should be understood only in the context of the first 2 punishable acts, and one of which is this one. No, the first punishable act, causing any serious disturbance in a public place, office, or establishment. The nature of the gathering, activity, or meeting is immaterial for purposes of this first punishable act because what is punished here is the disturbance that happens in a public place or in an office or an establishment, whether public or private. Also, the disturbance must be of a serious character, otherwise the crime will only be alarms and scandals under Article 155. Now, to be considered of a serious character, the offenders must have planned or intended to cause such disturbance. It must not be a spur of the moment thing. For example, supporters of candidate X happened to pass by the house where the supporters of candidate Y were having a meeting. As emotions were running high because the elections were nearing, some of the supporters of candidate X shouted political insults at the supporters of candidate Y, disturbing the attention of the latter in the process. Here, there is only a slight disturbance, and that the same was neither planned nor intended. Hence, the crime here should only be alarms and scandals under Article 155. This is actually based on a case decided by the Supreme Court. So, for as long as the same or the act that caused the disturbance was not planned or intended, then it will not be considered as a serious disturbance under Article 153. But the offenders, just the same, will be liable under the crime of alarms and scandals in Article 155. Now, the act causing the serious disturbance must not come under either Articles 131. I am referring to the crime of prohibition, interruption, and dissolution of peaceful meetings, or 132. I am referring to the crime of interruption of religious worship. Otherwise, Articles 131 or 132, as the case may be, should be the proper crime to be charged and not Article 153. Now, the crime is either Article 131 or 132 if the offender is a public officer or employee. Again, please do remember that under Article 131 or 132, the offender must be a public officer or employee. And such public officer or employee must not be a participant in the meeting or religious worship, because if the public officer or employee is a participant in such meeting or religious worship and he disturbs or interrupts the same, the crime will be disturbance of public order under Article 153 and not under Article 131 or Article 132. Also, a private individual, whether he be a participant or not in that meeting or religious worship, and he prohibits, interrupts, and dissolves peaceful meetings, or he prevents or disturbs the ceremonies or manifestations of any religion, he will be liable under Article 153 and not under Article 131 or 132. Reason? Only a public officer or employee can be held liable in Articles 131 and 132. Please take note of that. Second punishable act: interrupting or disturbing performances, functions or gatherings, or peaceful meetings. If the act is not included in Articles 131 and 132 of the Revised Penal Code. Who are the offenders for this second punishable act? The offender here can be a private individual, whether he is a participant or not in the gathering, or the offender can also be a public officer or employee who must be an attendee or participant in the meeting, because if such public officer is not an attendee or participant in such gathering and he disturbs the same, then the crime committed is either Article 131 or 132 and not Article 153. Now, a private individual who prohibits, interrupts, and dissolves peaceful meetings, or who prevents or disturbs the ceremonies or manifestations of any religion is liable under Article 153, not under Article 131 or 132. And what is the reason? The reason is only a public officer or employee can be held liable in Articles 131 and 132. Now, when is the disturbance or interruption considered tumultuous? The disturbance or interruption is considered tumultuous if caused by more than 3 persons who are armed or provided with means of violence. The effect when the disturbance or interruption is considered tumultuous is it increases the imposable penalty by 1 degree. Third punishable act, making any outcry tending to incite rebellion or sedition in any meeting, association, or public place. And fourth punishable act, displaying placards or emblems which provoke a disturbance of public order in such place. Let us treat these third and fourth punishable acts in Article 153 together. What does the word or the term outcry mean? The term outcry means to shout subversive or provocative words tending to stir up the people to obtain by means of force or violence any of the objects of rebellion or sedition. Now, having defined what an outcry is, the next question to ask is, when does an outcry or the displaying of emblems or placards become inciting to sedition or rebellion? The offender must have done the act with the thought of inducing his hearers or readers to commit the crime of rebellion or sedition. At this juncture, you must remember that criminal intent can only be shown through the overt acts of the offender. If there are no overt acts, then we cannot validly say if the offender had the intent of inducing his hearers or readers to commit the crime of rebellion or sedition. Pero yung pag-display ng emblems or placards tapos meron talagang nakalagay doon inciting the people to commit the crime of rebellion or sedition, then klaro na yung emblem na ginawa o yung mga writings na nakasulat sa placards have the intent or is for the purpose of inciting others to commit the crime of sedition or rebellion. So, the crime in such a case will no longer be the crime under the third punishable act, which is making an outcry tending to incite rebellion or sedition, but inciting to rebellion or sedition, as the case may be. When does an outcry constitute only disturbance of public order? Answer: if the outcry is only an unconscious outburst which, although rebellious or seditious in nature, is not intentionally calculated to induce others to commit rebellion or sedition, the crime is only disturbance of public order under Article 153. Fifth and last punishable act, burying with pomp the body of a person who has been legally executed. But before we attempt to discuss this fifth punishable act, we cannot do without mentioning Article 85 of the Revised Penal Code, specifically with respect to the last sentence of the said article. But allow me to read to you the full text of the said provision. Here it is. Unless claimed by his family, the corpse of the culprit shall, upon the completion of the legal proceedings subsequent to the execution, be turned over to the Institute of Learning or Scientific Research, first applying for it, for the purpose of study and investigation, provided that such institute shall take charge of the decent burial of the remains. Otherwise, the Director of Prisons shall order the burial of the body of the culprit at government expense, granting permission to be present thereat to the members of the family of the culprit and the friends of the latter. In no case shall the burial of the body of a person sentenced to death be held with pomp. This is the last clause or last sentence of Article 85 that relates with the 5th Punishable Act under Article 153. So, the last sentence of Article 85 prohibits the burying with pomp the body of a person who has been legally executed. On the other hand, the 5th Punishable Act under Article 153 provides the penalty or makes it criminal for the family of the death convict or for any other person to bury with pomp the body of such death convict. As a matter of fact, upon the completion of the legal proceedings after the execution of the death sentence, the corpse of the death convict will not be turned over to the family, but it will be turned over to the Institute of Learning, applying for custody of that cadaver for the purpose, of course, of study and investigation. But if there is no institution applying to have custody of the remains of the death convict, then the government shall order the burial of such body of the culprit at government expense, and then it will only grant permission to the members of the family to be present at such burial. They will not turn over the body of the death convict to the members of the family, but the members of the family will be allowed to be present at the burial of the said death convict. When you say burying with pomp, it means an ostentatious and splendid kind of burying the dead. And why is it not allowed? It is not allowed with respect to death convicts because it not only shows the defiant attitude of the convict's family members, but it also gives the wrong impression to the public that a death convict's life, no matter how heinous his crime was, should be celebrated. Take note, however, that this part of the article in Article 153 is already inoperative because, as what I have told you in my previous videos, Republic Act 9346 had already abolished the death penalty. Hence, the crime can no longer be committed.